conversation about representation. You told me that you wanted to represent yourself. You didn't want a lawyer appointed and you weren't going to be hiring a lawyer. I said, we can have that conversation. That's an extended conversation, judge and defendant. And I'm ready to do that so that we can move your case forward. Otherwise, you're kind of stuck until we clear that hurdle. You have a right to represent yourself, but I need to make sure that you are knowingly invoking that right and intelligently, which is not me telling you you're not intelligent. I just need to make sure you understand the consequences of self-representation. So that's what I was hoping we could get through today. But I always want to start by saying what is on your agenda so we can see if there's anything else.
State and national, and I can't be represented by no attorney. But I have a lot of issues with me being a national that I wanted to address. You said you were going to let me hear me. You're going to let me address all my issues last time I was here about me being.
Well, I did say that, but I said if you're going to address issues, I need to make sure you're representing yourself. Okay.
This is a classic sovereign citizen opener, separating the living man from the all-caps legal name to dodge jurisdiction. It might sound powerful, but in court, it doesn't change the judge's duty. The process stays the same. Identify the defendant, confirm their rights, and move forward. Watch how calm, consistent procedure beats loud legal theories every time.
I have to have my conversation first, but I need to ask you a bunch of questions about your background and make sure you understand the consequences of being your own lawyer. If you assure me that you got it, and getting all those things you want to represent yourself, I have to give you that right, and I will, and then you can share with me what your issues are, okay? You ready to work it that way?
Yes, sir.
Excellent. All right. Mr. Pierce, please tell me how old you are.
41 years old.
How far did you go in school?
11th grade.
All right. Did you ever get your GED? When did you get your GED?
2017.
Excellent. Are you able to read English? I know you can write in English because I got these and you actually mailed me something that
I wrote you a letter.
About 200 pages long. All right, so you can read and write and you can speak English. Have you ever worked? Tell me what kind of work you've done before.
I worked for Dollar Tree when I got arrested. I worked there for Airmark. I worked there for the Move Theater in North Carolina. I have my own landscaping business. I have my own record label at McDonald's, Burger King.
So you've had a bunch of jobs. Got it. All right, that's helpful to know. I appreciate you sharing that. Have you gone to law school?
I haven't gone to law school, but I have practiced, not practiced, I've been studying law.
You've been studying the law. Tell me how you've studied that.
Just reading, researching different case laws, sending out different statutes and codes and things of that nature.
Sure. Has all of your legal study been while you've been in jail, or have you also done legal study when you were out?
Both in and out.
Have you ever watched an entire criminal trial before, start to finish?
I done been to trial before.
So you've watched one then?
Yes.
Okay. What was that trial about?
Armed robbery. The 10 years I just did for armed robbery.
So you were charged with armed robbery,
yeah.
And that case went to trial?
Yes, sir.
So you were there from jury selection all the way through verdict?
To closing argument. I stopped before closing arguments and took 10 years.
Oh, you pled guilty?
Yeah, I tried right before they were finna come out for closing argument.
This right here is a Florida checklist. The judge isn't mocking the defendant. He's warning him. Representing yourself might feel empowering, but the cost is massive. You get limited research access in jail, no trained investigator, and only one chance to handle a very serious case.
The matter subject me to the court's jurisdiction.
Okay, well, indulge me for a minute and assume, you may think I'm wrong, but assume that I've decided that you are subject to the jurisdiction of the court. And you said, Judge, you're wrong. Okay, but I get to make the decision initially, and then you go to the Court of Appeals and they'll say McBurney was right, McBurney was wrong. But if I've decided that this court has jurisdiction over you and this case and your co-defendant, do you want me to appoint you a lawyer because you're stuck here anyway, or you still want to represent yourself?
I still want to represent myself, but I'm not under the court jurisdiction.
No chains?
Okay, my bad. My apologies. I'm not under the court jurisdiction, and I've been studying it long enough. Almost my whole family is nationals, and we know a lot about it, and we know for a fact the only way I could be subjected to a court jurisdiction is through a lawyer, because the birth certificate is a void contract, and through that contract, the birth certificate contract is what makes me subjected to the court jurisdiction.
Okay. I'm going to stop you again, not because I'm disagreeing with you. I am disagreeing with you, but we don't need to resolve that right now. I want to keep going with the discussion about representation. Before I get to the next question about the consequences of self-representation, if we fast forward and play this out, eventually you are either going to be pleading guilty in this case or you're going to trial. You're going to disagree about jurisdiction. I'm going to be very respectful and say, you know what? I hear you, Mr. Pierce, and you don't think I have jurisdiction or this court has jurisdiction over you. And I may be wrong about that, but we're still moving forward. Here comes a jury. We're going to do the trial. And so we'll go through that whole process. And I may be told I'm wrong by the Supreme Court, and then I'll have to fix that, and I will fix it. But there'll be this trial.
Notice the shift here. The defendant isn't claiming he can do better than a lawyer. He's saying any lawyer would make him subject to the court. That's the giveaway. This isn't legal strategy. It's pure jurisdictional fantasy. But the system runs on real procedure, not on wordplay or magic phrases.
That I should let you represent yourself. Let me tell you what you're charged with. One charges you with murder, and it alleges that you and Mr. Baker shot and killed Samuel Curtis Harris Jr. Counts 2, 3, 4, 5, and 6 and 7 and 8 are all what we call felony murder, which is you and Mr. Baker caused the death of Mr. Harris by being involved in a different crime: attempted robbery, armed robbery, aggravated assault, being a convicted felon, and having a firearm. You and Mr. Baker are charged with attempted robbery, and the allegation is, and again, these are just allegations. It's not proof of anything, but it's letting you know what you're charged with and what you'll need to defend against.
Okay.
But the attempted robbery allegation is that in February of 2024, you and Mr. Baker approached Samuel Curtis Harris Jr. on foot on Mitchell Street, right near here, with the intent to take his property. Count 10 charges you and Mr. Baker with armed robbery, saying, in fact, by using a gun, you took his property. In fact, what you took from him was a firearm. Count 11 charges you both with aggravated assault for shooting Mr. Harris. 12 is possessing a gun in connection with these crimes that I talked about. Same with 13. 14 is just Mr. Baker. 15 is you. And it says that on that date you had a firearm, but you were a convicted felon because back in 2010 you got convicted of something in Clayton County. Also, you got convicted of something here in Fulton County in 2016. I guess that's your robbery you were talking. So the thrust of it is, the allegation is you and Mr. Baker robbed Mr. Harris and shot him, and he died as a result of that. That's what you're charged with.
Now the weight really hits. We're talking about charges like murder, armed robbery, aggravated assault, and felony possession. This isn't a traffic ticket. Stakes like these are exactly why judges urge defendants to accept counsel, because one misobjection could cost you decades behind bars.
Jurisdiction, and that's the highest jurisdiction on it. This is my oral request for me changing the court's jurisdiction over me here today. I have not contracted with the court in any kind of way, and I don't plan on contracting with the court in the near future. I have been forced to come here against my will and God-given rights under threats enforced by your government officials, which is kidnapping. Your courts have no jurisdiction over me, and I stand on the land and soil jurisdiction to have proof of it when I came to court on January the 30th, 2020. Your courts, plus in Louisville versus Mott, any tribunal finds absent of proof of jurisdiction over a person and subject matter, the case must be dismissed. Your court's jurisdiction is the jurisdiction of the sea, which is an admiralty and maritime laws, which is also a military tribunal, and the courts are known as a ship of war, a privateer, or a battle. I am on a public
Land jurisdiction versus sea jurisdiction. Straight out of internet templates. It sounds like compelling storytelling, but it's completely irrelevant in criminal court. Judges often let it go on record just so the defendant feels heard, then move forward applying the actual law that matters.
I am also requesting your oath of office, Your Honor. Notice that Trump sent out goals as follows. Notice to patriots. Date, January the 4th, 2025. This is to inform all patriots that effective immediately, our government and government corporations are hereby dissolved due to breach of oath. Additionally, our statutory and foreign laws are also dissolved. The only legal framework that remain in effort are constitutional law as outlined in Article 61 of the Magna Carta and established common law. This directive is especially for corporate bodies and government workers. Any government corporate body, including police, judges, lawyers, and any individuals operating in these capacities must cease operation immediately. Those who continue to operate after this notice will be liable for prosecution for fraud and breach of oath. It is imperative that...
Here's the viral moment, a supposed directive dissolving government authority that racks up likes online. But in court, it earns silence and then a trial date. Jurors won't be asked about maritime flags. They'll be asked about evidence.
Reject, renounce, and remove any and all alliance to any king or prince, any foreign state, any foreign government or flag. I declare on the penalty of perjury on the public law of the United States of America, the Danjur government, that I have never knowingly, wittingly, or voluntarily pleaded myself to any incorporated entity at all, including but not limited to any incorporated church, synagogue, mascot, I declare on the penalty of perjury on the public law of the United States of America, the Danjur government, that I have never knowingly, wittingly, or voluntarily pleaded myself of any foreign state, foreign sovereign, or separated myself from my birthright political status as American state national. I declare, publish, and affirm on the penalty of perjury on the public law of the United States of America that I am a lawful inheritor, acting with full rights and authority, responsibility, and honor now and always while my tenure on earth shall last.
The birth certificate contract, the all caps name, the trademark talk. It all sounds technical, even a little legal-ish. But courts deal with facts and law, not metaphors. If the evidence points to a robbery and a shooting, no amount of paperwork or word theory blocks a guilty verdict.
Set forth in a board schedule will be assessed as the total amount of damage set forth herein times 3 for a total of all damage added to 3 times the damage for primitive and other additional damages for a total of $1,019,631,000 US dollars.
$1 billion, you're at to the B.
Yes.
Okay, that's a lot of money.
And that's just for the amount for me being incarcerated these 120 plus days. Your Honor, all laws are commercial and all laws are not laws.
This part is dangerous. When a defendant starts calling court treasonous and threatens punishment, it can escalate fast. Editor's note: keep this moment, but don't sensationalize it. There's no gore here, but keep a lower third note so viewers understand the real risk of antagonizing the bench.
And the laws we are abiding by are foreign laws from Great Britain, which means that the United States, the corporation, got Americans abiding by laws from Great Britain, which is also illegal. That's why, again, you have BAR, which stands for British Accredited Registry.
What page are we on?
I'm almost through now. I'm closing now.
All right.
I am 1, chancellor jurisdiction of the courts. I have a high jurisdiction. 2, I am demanding to see the state of Georgia to show up in proper persona. This must be made by self and not an attorney. 3, I am demanding that the courts present a living injured party because our citizens are considered dead entities, corporations, legal fictions, and artificial persons. 4, I am requesting the judge oath of office and the first and last name of every court official in this courtroom before we proceed. I am demanding who gave the courts permission to use the all caps trust, which is a copyright and trademark. I am putting the courts on notice.
Dismiss the case or pay my trust. That single line sums up the sovereign citizen arc, turning criminal exposure into a civil-style invoice. Judges usually let the person speak, then calmly return to what actually matters: calendars, motions, and evidence.
Because an attorney is an officer of the court and will automatically subject me to the court jurisdiction.
And I hear you on that, which is why we had the first part of our conversation, and I've concluded that you've got the ability to and the desire to represent yourself. We'll do that. I appreciate you making that record. As you and I agreed, you won't need to do that again. You've now made all those objections, made it very clear that there's $1 billion plus, and I get it that that number is increasing. Every day you're in custody and people are trying to contract with you when they shouldn't, all that. You've made a healthy record of that. You're welcome to file things now because you are your own attorney. You can now file things of record. into the dom. But when we see each other again for whatever the next court event is, we can use a shorthand where you can say, I renew the...
This is strong judicial management. You've made your record. No need to repeat it. That's how the judge keeps order and dignity in the room, while preventing the next hearing from turning into another 20-minute manifesto.
Did the law library still do it?
You should ask, but don't be disappointed if the answer is no. I think there were issues with, a USB drive is so small and it ends up in someone's pocket, and then it's on the 7 North, and I'm not saying you did.
Is it part of me possibly I ain't got to tell you, they can stick it in, sit there with me to watch the whole video.
You tell, hey, if you can sell it and make them do it, that's great. I'm not saying no. It's not my call. It's not his call. I appreciate everyone's patience. Mr. Pierce, we'll get you back here either because you filed something we need to talk about, or it's time for you to look at the digital discovery. But you file what you want to file, and I promise you we'll work through.
Here's the real self-representation reality check. How do you review surveillance footage from jail when the facility doesn't allow USBs? You can't. And that's not ideology, that's logistics. Trials are won through discovery and preparation, not through speeches about flags or sovereignty.